So in the previous lesson, what we did was spend some time talking about delegated legislation within the parliamentary lawmaking system. This lesson is going to talk about the various different controls that are in place on delegated legislation. Now, while delegated legislation is a necessary tool for the efficient operation of law, it can sometimes require a system of control in order to ensure that the users of delegated legislation and the instruments of delegated legislation themselves do not exceed the powers granted by Parliament and remains within the scope intended by the parent act. Several mechanisms exist for controlling delegated legislation. Primarily, when we think about oversight by Parliament and by the courts, and also through the Legislative and Regulatory Reform Act of 2006. This lesson is going to examine the various different controls on the use of delegated legislation that are in place. Specifically, we're going to talk about controls that are in place by Parliament. We're going to talk about specifically the Legislative and Regulatory Reform Act of 2006. And then we're going to talk about controls that are in place by the courts. So beginning first then, Parliament has the ultimate authority over delegated legislation. And so while it cannot typically reject specific pieces of legislation without a formal challenge, it maintains the ability to scrutinize and control the process of implementing legislation through various different instruments and institutions. So, for example, there are a number of scrutiny committees that exist. First of these is the Joint Committee on Statutory Instruments, the GCSE. This is a parliamentary committee that is responsible for reviewing various different statutory instruments, hence the name. And they review statutory instruments in order to ensure that they comply with a number of procedural requirements and that they, importantly, do not exceed the powers that are granted by the Enabling Act. Remember, statutory instruments and delegated legislation more generally is essentially under the auspices, it is authorized under the auspices of a piece of primary legislation, which is authorized by Parliament and is then subjected to the basic principle of parliamentary sovereignty. The GCSE checks for technical errors on the pieces of statutory instruments and also checks whether or not the statutory instrument has been made according to the prescribed procedure. So, for example, whether the affirmative or negative procedure has been correctly followed. The affirmative or negative procedure, something we looked at in the previous video. In addition to the Joint Committee on Statutory Instruments, we also have the Committee on the Merits of Statutory Instruments. This is a committee which will go to review the substance of the delegated legislation. It will focus on the merits of the legislation, such as whether it is reasonable, fair, or necessary in terms of not only its implementation, but also the manner in which it exists. These committees can draw attention to statutory instruments for further parliamentary discussion or even for challenge. But the problem that they may have is that they cannot formally annul them themselves. But their reports can prompt Parliament to take action regardless. Under the affirmative procedure, delegated legislation must be explicitly approved by Parliament in order for it to come into force. This is the most rigorous form of parliamentary control, and it makes it very similar or almost akin to the basic provisions of passing a piece of legislation, in the sense that it requires both houses of Parliament, the House of Commons and the House of Lords, to approve the statutory instrument before it comes into law. For example, a minister may lay a statutory instrument before Parliament, which then has a fixed period, often 40 days, in order for there to be debate and approval on it. By contrast, under the negative procedure, delegated legislation automatically becomes law unless either Houses of Parliament objects to it. So rather than the affirmative procedure, which is not going to become law until Parliament approves it. The negative procedure allows for it to become law unless Parliament objects or rejects it. If there are no objections within a specified time period, then the legislation becomes effective without any further parliamentary involvement. Now, Parliament retains the power to reject delegated legislation, but the process to reject delegated legislation requires active intervention. So, for example, it might require a member of Parliament to table a motion for annulment and for both houses to agree on this particular procedure. The negative procedure is more common when it comes to the passage of delegated legislation, and that's because it is less burdensome when it comes to the forms of control, particularly when we think about some of the more technical esoteric administrative rules that may be passed through delegated legislation. You also have, under the auspices of the Legislative and Regulatory Reform Act of 2006, the introduction of something known as the super-affirmative procedure. The super-affirmative procedure is a more intensive form of parliamentary control, particularly when we think about legislation that has an effect on regulatory changes. This procedure involves a number of different stages, including, but not limited to, consultations and reports from the parliamentary committees. This is all before the legislation can be finalised. Even when delegated legislation is made using the least stringent of control mechanisms, i.e. the negative procedure, then we can still have members of Parliament and members of the House of Lords to debate the regulation, and even if it is through a negative procedure, they can have the option to reject it. This form of control is less direct than the affirmative procedure or even the super-affirmative procedure, but it still provides Parliament with a certain degree of oversight. Finally, in terms of the power to revoke or amend, Parliament can also pass further acts or resolutions that can either revoke or amend the previously made delegated legislation. This is if it is deemed particularly inappropriate, excessive, or even no longer necessary, and falls within a very similar remit as the basic doctrine of implied repeal that you see when thinking about primary legislation and parliamentary sovereignty. More on that on previous videos. So one of the more important areas of legislation is the Legislative and Regulatory Reform Act of 2006. It's a significant piece of legislation that is aimed at reforming the way in which regulatory powers are delegated to ministers and other authorities. Now, the Legislative and Regulatory Reform Act primarily applies to legislation that seeks to remove burdens or to reduce the administrative impact imposed on businesses, individuals, and public authorities. It is therefore often used to make minor changes to the existing regulatory framework in order to make it more efficient and, most importantly, make it less restrictive. Within the Act, there are a number of different provisions and implementation processes that can take place. One such example includes regulatory reform orders. This Act enables ministers to make a regulatory reform order, which is a form of delegated legislation aimed at removing or reducing significant burdens. So, for example, redundant regulations or unnecessary compliance requirements. It also introduces, as I noted on the previous slide, the super-affirmative procedure. This is for certain types of delegated legislation, and it is a more rigorous procedure than that of the ordinary affirmative procedure. Under this, any kind of proposed regulatory reform order must be laid before Parliament for scrutiny, and committees must review them before they are debated and approved. Ministers must also consult with interested parties. This is part of the consultation requirement associated with the legislation. This might include affected industries, affected individuals, and affected groups before they go about the process of actually proposing a regulatory reform order. This consultation process is intended to ensure that regulatory changes are well thought out and well understood in terms of the impact that they're going to have on the people that they are aimed at essentially thinking about. And then finally, the provision includes regulations that require any kind of regulatory reforms to be made under the legislation to be proportional to the intended outcome. And this, of course, avoids the overreach in curtailing or limiting regulation. So with all of this being said then, what is the impact of the Legislative and Regulatory Reform Act? Well, its purpose was to balance the flexibility needed for efficient regulation with the need for there to be parliamentary oversight over delegated legislation. And in that regard, it allows ministers to make regulatory changes, but it also provides parliamentary committees and the public with a means of scrutinizing those changes in greater detail. One of the most important parts of this is the super affirmative procedure, which essentially ensures that power to amend regulation is properly controlled and it limits the potential for excessive use of delegated powers without appropriate checks. In addition to Parliament, then, the courts can also play a very important role in the control of delegated legislation. So this is in order to ensure that the legislation adheres to both the intent of the enabling or primary legislation, but also the basic fundamental principles of justice and fairness. And I want to begin with the concept of judicial review. Now, judicial review is not something that you have to know too much about when you think about A-level law, but if you decide to go on to study law at university, you will do a module called Constitutional and Administrative Law. It's one of the core and foundational modules that any law student has to do. And within that area of study, you will do judicial review in quite a lot of detail as part of the administrative law section. But ultimately, when we think about judicial review very briefly here, the courts can review the legality of delegated legislation, and this is to ensure that it does not exceed the powers that are granted in the enabling legislation, in the primary act. This is based on a principle known as the ultra vires doctrine, meaning the translation meaning beyond one's powers or beyond the powers. And if delegated legislation is found to have exceeded this authority that was given by Parliament, then the courts can declare it to be invalid. Now, judicial review may examine whether the legislation was made by the correct body or individual, so whoever had the statutory authority to do so. It might examine whether the procedure for creating the legislation was followed properly. It might examine whether the delegated legislation is consistent with the parent legislation, with the enabling legislation in terms of their scope and their intent. Or it might determine whether the delegated legislation complies with the basic principles of fairness and natural justice. And so the ultra vires doctrine is particularly important. The courts have the power to declare a piece of delegated legislation as acting beyond one's authority, exceeding the scope of the authority that was granted by the enabling statutes. This can occur in a number of situations, such as, but not limited to, when delegated legislation addresses matters that are outside the specific powers conferred by Parliament. So when Parliament passes a piece of primary legislation with the authority to create delegated legislation on the part of a particular administrative institution, they might be very specific about the areas, about the contours of which they can address the issue, and maybe anything that steps outside of that addressing is viewed as ultra vires, is viewed as beyond one's authority. You could also see that the courts issue an ultra vires doctrine where the legislation contravenes basic constitutional or human rights principles. So, for example, if an enabling act, a piece of primary legislation, was to grant a minister the power to regulate specific issues on, let's say, traffic control, but the minister starts to enact regulations that are completely unrelated to that matter. Let's say they start talking about tax regulation. This regulation would be considered ultra vires and therefore would be void and of no substance. Another couple of issues that I want to just touch on briefly is the ideas of substantive and procedural review. So substantive review refers to the situations in which the courts can examine the content of the legislation itself in order to ensure that it does not conflict with fundamental rights or go beyond what is necessary. Procedural review is where the courts can review whether the correct procedures were followed in the making of the delegated legislation. So there are sort of two ways in which, or there are two modes of analysis for thinking about delegated legislation. You could think about the substantive content of the legislation itself, and you can also think about the ways in which that legislation came into being. The procedural review examines the latter, so things such as ensuring proper consultation, proper notice, or parliamentary scrutiny that is required by the Enabling Act is all part of the procedural review process, whereas thinking about what the actual legislation says is part of the substantive review process. It also has to be said that the legislation has to comply with the Human Rights Act. So the courts can review whether or not a delegated legislation is compatible with the Human Rights Act, which is incorporating, of course, the European Convention on Human Rights. If the legislation violates human rights, it might be struck down or declared incompatible. Now, the Human Rights Act includes a number of provisions that are able to essentially ensure compliance with that legislation. Section 3 of the Human Rights Act, for example, requires and compels courts to read any kind of potential difference in terms of legislation versus the Human Rights Act in a way that complies with human rights legislation. And then Section 4 addresses the situations in which that is impossible to do. If it is just completely impossible to read a piece of legislation in compliance with the Human Rights Act, then the courts can issue what is known as a declaration of incompatibility, which is a declaration to Parliament to let Parliament know that this piece of legislation is incompatible with the Human Rights Act. Now, while Parliament doesn't actually have any legal requirement to change it, they often have the political constraint to do so. And again, this illustrates the distinction between legal sovereignty and political sovereignty, something we spoke about in a previous video. Finally then, let me just speak very briefly about judicial review of other forms of delegated legislation. So the courts also have the power to review bylaws that are made by local authorities or other kinds of local bodies. Bylaws can be challenged on the grounds such as exceeding the powers granted by the Enabling Act or being considered unreasonable. So the judicial review of bylaws and other forms of delegated legislation acts in a very similar way to the delegated legislation that we see implemented by things such as statutory instruments.